come to the next step, the appointment of arbitrator and the constitution of the tribunal. What do we look out for when we appoint an arbitrator? Do we appoint our friend? I mentioned before, the arbitrator doesn't have to be legally qualified. He can be anyone off the street. Anyone here could be appointed an arbitrator as long, as the appointing party, wishes to nominate you. But more often than not, some of the things that we try to do when we look out as to what kind of arbitrators do we appoint, we look at, for example, their qualifications. If this is a construction dispute, you try to get a lawyer who's or an engineer, or a lawyer who has an engineering background. There's quite a few of them, in these construction arbitration, because they'll be able to understand what the facts are and what the technical terms and issues are. And another thing that we need to know is the dynamics in a tribunal. So if we have a tribunal consisting of 3 arbitrators, they are all people, you see, and they each can sort of exert influence over another as to how to decide this particular arbitration. So, for example, if the other 2 arbitrators are really senior, lawyers, and you appoint someone who's a bit more junior, he may not have that ability to try to persuade, or to influence the other arbitrators. So, the human aspect, human psychology comes into it, as to who do we appoint as an arbitrator. Now, since we know an arbitrator can be anyone, whether it's legally qualified or not, then the question is, so can I appoint like my friend or my family member or my relative, to be an arbitrator in this case? Now, the answer is not quite so, because there's an issue of conflict of interest, where people can challenge the appointment of an arbitrator by saying that he's biased, he's not fair, or he's not impartial. So an issue of conflict of interest arises. Next slide, please. So how do we know whether there's a conflict of interest? In arbitration, we refer to the IBA guidelines on the conflict of interest, where it sets out a number of scenarios where it would be considered a conflict of interest. And in this case, these are what they call IBA red list. So one example is if there's one of the arbitrators is a legal representative of the party that is in the arbitration. So clearly, he's been working for the party, so he's not a suitable candidate for it. And for example, if the arbitrator is, let's say, a director, of the company that is in dispute, then clearly a conflict of interest as well. And if they have significant financial interest, perhaps this arbitrator holds shares in this company. All the sort of things that we have to sort of dig out in forensic when we try to challenge the nomination of an arbitrator. Next slide, please. We come to the next stage, which is interim measures. Now, what are interim measures? These are essentially orders that are made by a court or a tribunal, before a final judgment or award has been issued. And why do we need interim measures? Because some of the times, before an award or judgment can be issued, parties may have taken steps, to try to dissipate their assets, try to move all the funds out of certain country, try to hide the funds in another country, try to destroy evidence, and try to do all sorts of things. So we need interim measures to maintain the status quo and stop everything before the judgment or the final award is issued. So before a tribunal is constituted, sometimes there's a need for us to take measures, interim orders immediately. Parties are doing something. Say, for example, some of the commodities, grain or beans, are being stored somewhere, and we need them to release those grains, because otherwise, by the time we finish the arbitration, all of these produce will have been, destroyed. They've already become rotten and worthless, you see. So we need interim orders to help us, in this aspect, to protect the asset in question, because otherwise, it is meaningless. It's just a paper judgment in the end if we win, but the asset is all gone. So one case that I'd like to bring to the audience attention is this PT Pukwafu Indah against Newmont, Indonesia. Now, the PT Pukwafu Indah is a company owned by the Maruk family in Indonesia, and they have holdings in copper and gold mines in Indonesia. And this is a very interesting case, because what has happened is that the respondent, Newmont Indonesia, is actually sort of like a creditor of PT Pukwafu Indah. And what's happened in this case is that they've alleged that PT Pukwafu Indah has breached the contract and all that. And what what occurred is that PT Pukuafu had actually commenced litigation proceedings in Indonesia, even though there was an arbitration clause. So what they sought to do in this case is to obtain an anti-suit injunction. So what is an anti-suit injunction? It basically is an injunction order that stops a party from commencing parallel litigation in another jurisdiction. We stop this party from commencing court proceedings in Indonesia or in Thailand or other jurisdictions. We stop them until the arbitration is over. So in this case, it's pretty fascinating because what has happened is that the anti-suit injunction in this case was granted, and what PT Pukuafu Indah sought to do was to try to remove this injunction order that was issued by a tribunal. But what is interesting to note is that in Singapore law, there's actually no recourse for parties to try to set aside or to overturn a tribunal's injunction order. It's a peculiar aspect of it. So it's one thing for us to take note that in case we are thinking about injunction orders in arbitration seated in Singapore, rather than going to a court to obtain an injunction, which can then be overturned, perhaps one of the considerations that we could try to get an order from a tribunal, because under Singapore law that cannot be set aside. Next slide, please. So the next stage, after the arbitrators have been appointed and all that, is that parties are get to decide how the pleadings are to be like. Now, in arbitration, there are two types of submissions, as it were: pleadings or memorials. Now, what's the difference between pleadings and memorials? Now, for pleadings, they come a bit more from a common law tradition. You have your statement of claim, then the other side files a statement of defense. Then you file your statement of reply, and the other side files a statement of rejoinder. And you have witness statements and reply witness statements. It's a stage-by-stage process. Whereas in the memorial system, it requires parties to submit upfront, at the relevant date, your pleadings, your witness statements, your expert reports, all of it together at once. So it has certain dynamics in issue, because if we go by the pleading system where you go by step, you kind of have the opportunity to first look at what the other side's case is, and then to try to alter your case, to try to edge the other person out. Whereas in the memorial system, it's a bit like when you play some sort of card game, it's really like a show hand. Everybody shows what their arguments are, what evidence that they have, right at the start, and they try to determine the issue then. Next slide, please. So after we have the pleading process, we come now to the document production process, which is really a common law thing. And what governs document production in arbitration is the IBA rules of evidence. And in document production in arbitration, we have what we call a Redfern schedule, named after Alan Redfern, who wrote the textbook on international arbitration, Redfern and Hunter. And so what you see here is a table, and again, words are pretty small, but basically what happens is that you progress from left to right, step by step. So one party requests for a particular type of document, and they state what is the relevance of this document to the case. Then the other party then states their objections to it, why they think that this document should not be produced. And then the requesting party gets one more shot at trying to respond to the objections. And lastly, at the last column, the tribunal decides the outcome: should this document be produced or not. Next slide, please. So when we come to hearings, in civil law traditions, it's more of an inquisitorial process, a judge-led process. But in international arbitration, it's more of a common law system of adversarial system. Both sides, go at each other, and you have the cross-examination of fact witnesses. And interestingly enough, for expert witnesses, there's actually a process or procedure called witness conferencing, or informally known as hot tubbing. Hot tubbing of expert witnesses, because what you do in the hearing is that you basically take both parties' experts, you put them together, and then when you ask a question, both of them get the opportunity to respond. They can sort of respond. Say one expert says, "Oh, I disagree with this point." Then the other expert can, upon hearing the answer, immediately say, why why he thinks this other expert's opinion is wrong and all that. So it promotes a discourse between both parties' expert, so that the truth can really be found. Next slide, please. So now we come to the other aspect, which is challenging the award. So now that the arbitration is done and dusted, the arbitrator has issued the award. What happens next? Now it's usually at the enforcement of the award itself, or the challenging of the award. Now, what is the difference between challenging an award or resisting enforcement of an award? Now, earlier I mentioned that one of the components in an arbitration agreement is the seat of arbitration. So the seat of arbitration is not just the place where you hold the arbitration. It has legal significance and repercussions. So for example, if we put the seat of arbitration to be Singapore, what happens then is that when the arbitration award is issued, if one wants to annul the award or to set aside that award, they have to go to the Singapore courts. The Singapore courts have curial oversight and jurisdiction over this arbitration award. So it's quite important, when we draft the arbitration agreement, to think about which seat do we want. Do we want Singapore, or do we want, say, Switzerland, and all that? Each of these countries have their own pros and cons. Say, for example, take Switzerland, because I've worked there for a while. If you go put Switzerland as the seat of arbitration, what happens is that when the arbitration award is issued, you have 28 days to try to submit your submissions to set it aside. You have only 28 days. So what happens is that there's a mad rush, and we start drafting our submissions. So there is a time limit of 28 days for arbitration seated in Switzerland. But if you seat an arbitration in Singapore, for example, you have 3 months. So these are some strategic concerns that we may want to think about, whether, to seat it in Singapore or in Switzerland, it has repercussions after the award is out. And the other aspect about the seat of the arbitration, I think I should also use another Indonesian party case as an example about the seat of arbitration. Now, this particular case involves PT Garuda Indonesia against Bergen Air. Now, this took place, sometime in 1998, 1999. Now, what happened in this PT Garuda Indonesia case is that there was an arbitration. The governing law is Indonesian law, and the seat of the arbitration is in Jakarta. Okay, and during the course of this arbitration, parties, had a discussion. And during 1999 in Indonesia, as Indonesian friends would know, it was a bit of a ruckus in 1999, and so parties expressed certain concerns about having the arbitration being held in Jakarta. So there were discussions of having the arbitration, venue moved to, say, Switzerland, but eventually they decided on Singapore. So the arbitration, note the difference, the seat of the arbitration is Jakarta, but the venue of the arbitration is in Singapore, meaning where the place of the hearing and all that is held was in Singapore. Now, after the arbitration award was issued, which was not in favor of PT Garuda Indonesia, what PT Garuda Indonesia tried to do in this case then was to go to the Singapore courts and argue that this arbitration is not seated in Jakarta, it's actually seated in Singapore. So Singapore courts have jurisdiction over it to set aside this award. Now, this shows a little of the confusion, that PT Garuda Indonesia might have had at that point in time about the difference between a venue and the seat of arbitration. So naturally, at Singapore courts, they pointed out that there's a difference between venue of arbitration and the seat of arbitration, and they found that Singapore courts had no jurisdiction over this particular arbitration, and that when parties had decided to have the arbitration held in Singapore, it did not mean that they had changed the legal seat of the arbitration to Singapore. It just meant that the arbitration was simply held in Singapore. The legal seats still remain in Jakarta. And so if you wanted to set aside the arbitration award, you had to go to courts in Jakarta. And that was the outcome of that case. And so very significant repercussions, if you ask me. And so now when we talk about how do we check? So now that we've gotten the difference, between a venue of the arbitration and seat of the arbitration out of the way, let's talk about how do we challenge this award. So let's say I receive an arbitration award and it's not in my favor at all, and so I wish to set aside the arbitration. So when you want to set aside the arbitration, you go to the seat of the arbitration. Let's say in this case, the seat of the arbitration in Singapore. So you go to Singapore courts to try to set aside the arbitration. Now, what is the effect of setting aside this arbitration? The effect of it is that this arbitration award simply ceases to exist. So if you go to a seat and you set it aside, you succeed in it, what happens is that you essentially have just destroyed the arbitration award. You can't enforce it anywhere else. It's just been rendered null and void. Yeah. So that's the difference between setting aside the award and resisting enforcement. Now, what is resisting enforcement? Resisting enforcement happens, let's say, in an arbitration where it's seated in Singapore, but there are some assets, let's say, in Malaysia, and so I bring this arbitration award to the Malaysian courts to try and enforce it. And parties can resist enforcement of it. They can succeed in the resistance of the enforcement, and if they succeed, that cannot be enforced in, let's say, Malaysia. But the arbitration award still exists. It's not rendered null and void. So you can still bring it to another jurisdiction where they might have assets to try and enforce it. Yeah. So that's the difference. If you manage to successfully resist enforcement of an award, it just means that it cannot be enforced in that particular court or jurisdiction. But the arbitration award still exists. But if you set it aside, it doesn't exist anymore. You can't bring this to any other jurisdiction to enforce it. Now, I must mention at this point some of the peculiarities. A very notable example, where a certain jurisdiction does not subscribe to this concept. Now, that jurisdiction is in fact France. France doesn't subscribe to this jurisdiction. They subscribe to their own doctrine of delocalization. Now, what that means is that they do not believe that, if an arbitration has been set aside in the seat of the arbitration, it ceases to exist. So basically what this means and what the practical implications for all of us is that if an arbitral award has been set aside in the seat of the arbitration itself, it cannot be enforced in any other jurisdiction except for France, because France, the courts have taken a different view to it. So this is quite an interesting aspect, when we talk about resisting enforcement and setting aside, we need to know that certain jurisdiction, in fact the only jurisdiction really is France, which still recognizes the award. So when it comes to enforcing award, even though it's been set aside, we can still bring it to the French courts if they have assets there and to try to enforce it.